Education is first and foremost, because a lot of folks don't know that they have a civil remedy. And I think education starts on the front lines with advocates, prosecuting attorneys, law enforcement, to make sure that in their conversations, they let a victim or survivor know that, hey, maybe you need to talk with a civil attorney as well, because that's an option. Second is to educate on the interplay between the criminal and civil process. You don't have to have both at any point. You can have a criminal case without a civil and a civil without a criminal. While there are parallels, and there are certainly some things to be gained in the civil case from the result of the criminal case, it doesn't mean that one is dispositive of the other. On the civil side of things, you have a completely different burden of proof, a much lower burden of proof. And we've all probably heard the term through television or movies. In criminal cases, prosecutors have to prove their case, their prosecution, beyond a reasonable doubt. Well, in the civil case, we have a much lower burden of proof called a preponderance of the evidence. But I would just add, and I say this because I always want to encourage victims and survivors, or at least educate them so they're not, deterred in pursuing a claim, is that even if there wasn't a police report, or maybe there was a police report, but there was a decision not to prosecute, or maybe a decision to prosecute, but later the charges were dropped, it doesn't matter. Talk with a civil attorney who is experienced in this field to get a complete and separate evaluation on whether you have a civil claim. It's a different analysis.